All right. Well, let me ask you this then, since you decided to volunteer this. As between your two girlfriends, would there be any reason they would share a number?
No, there's no reason that they would share. No,
So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same number that you're calling from the jail?
now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. Vesey, but Mrs. Vesey is right there.
Okay, do these two women know each other?
Yeah, they know each other for
Oh.
sure. I mean, like I said, we was in a three-way relationship. So like they know each other for sure.
Okay.
And Mrs. Vesey right there, if you would like to call her up here.
No,
Or she can attest it. I can't talk to her. I got both of them pregnant at the same.
Court calls case People versus Control Cooper.
For the people.
Your Honor, Peyton DeWitt, student attorney, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple.
Oh, really? Seriously? Okay, cool. Permission to practice is granted.
Thank you, Your Honor. Please state your name for the record.
Control Cooper. Thank you.
Your Honor, at this time, we waive my client's right to a preliminary exam.
Is that correct, sir? And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yeah. And you understand that that means that you'll not have that hearing, that you'll proceed to circuit court for further resolution. Yeah. People also waive their right.
That's right.
Preliminary examination having been waived. Sir, turn around.
You ain't got to talk to me like that. I'm gonna turn around though.
Turn around, please.
Thank you.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Is that correct, counsel?
Yes, it is.
Pretrial will be set for
July 25th at 1:30 before Judge Slate Thursday.
July 25th, 2024, 1:30 Slate Thursday. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Daniel Greenwood.
Your Honor, good morning. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Greenwood, who appears to my right. Mr. Greenwood, can you state your name for the record, please?
Daniel Lowell Greenwood.
Good morning.
Your Honor, we're waiting on, I believe, just one 911 call that should be in today. We were going to set this for an exam. Other than that, discovery is complete.
That is correct, Your Honor. The 911 call has been requested already this week. Mr. Holtman has been very quick with turning those over. So as soon as I get that, I will share that with the defense.
All other discoveries complete.
That is correct.
Yes, Your Honor.
No adjournment will be given if that call is not here. You understand that, counsel?
Understood, Your Honor.
People have their witnesses available the 30th.
We will do our best.
Preliminary examination in person, July 30th, 2024, 9 a.m. That is before. Exactly. For me. Bond, it's before me. Bond continue.
Thanks, Your Honor. Thank you.
Yes, another attorney. Court calls the case of the People versus James Johnson.
Prosecuting attorney working with on behalf of people.
Sam Bernstein for Mr. Johnson, Your Honor.
Here. Yeah.
What's going on, man?
Not much. You look good in orange.
No.
All right.
Oh, yeah. So we're asking court to please set this for a preliminary exam, Your Honor.
Your Honor, we have all discovery shared with the exception of the 911 call that was requested earlier this week. It should be over to Mr. Bernstein by the latest on Monday. My expectation would be more likely that it gets to him tomorrow. Then the court, well, I would like to address.
Why don't you go ahead and address Bond?
So I understand in this case, bond is currently set at 10,000, cash or surety with no 10% privilege. We did request 150,000 on this case originally. I understand he has his bond currently denied out of the circuit court, and multiple holds in this case. I am actually requesting that bond be raised today, as well as his phone privileges be revoked. I am
Now the stakes just went up. The prosecution isn't simply asking the judge to keep the bond in place there, asking for stricter conditions based on what they claim happened after Johnson was already warned about the court's restrictions. And when the alleged violation involves repeated contact with the protected person, that's exactly the kind of detail a judge is going to take seriously.
concerned because the way that I see this playing out is that he was taken into custody for this event that occurred back on May 2nd. After he was taken into custody, he was in custody for a period of time, then was released. Before he was released, we had stipulated to adjourn this case to May 23rd. On that day, he failed to appear in a bench warrant was issued. He was then picked up and arraigned on the bench warrant on July 9th and given the 10,000 cash surety without 10% privilege. In the time that he was in custody before he was released and since he has been picked up, he has called the victim 105 times at her personal number, as well as called the family line 110 times, where the victim answers that phone among other people a period or a number of times.
This is the moment where Johnson's explanation directly collides with the prosecution's evidence. His defense is essentially saying, yes, those calls happened, but they weren't to the victim. That's a major distinction. The problem? The prosecution says the number belongs to the victim. So now everything may come down to the phone records and, potentially, the actual recordings.
I don't know what contacts he had with the victim while he was out of custody, but given his failure to appear previously, as well as the extensive violations in the form of calling the victim, I would be asking for the increase in his phone privilege to be revoked today.
Your Honor, as far as the phone calls go, Mr. Johnson states adamantly that he's not called Miss Vesey. He says that it was another woman that he's been calling, and that he has not had any contact with Miss Vesey since he's been in jail by phone, Your Honor.
I apologize. It is the victim's phone number because the victim has called our office and provided that phone number that he has called 105 times as her point of contact to our office.
That's my phone. That's not her number. I call my other girlfriend. That's my phone.
He says he's calling his other girlfriend, Your Honor. I'm sure Miss Barroso will get me the phone calls. I'll listen to him ASAP. If there's something different, then I'll know within like a day or two. I know what Miss Vesey sounds like on the phone, so I'll be able to tell whether it's her or not.
Your Honor, I'll say something, Your Honor.
Usually doesn't work well, but go ahead.
I know. Yeah, the number that I've been calling, I got two girlfriends. One is Mrs. Vesey and the other is Jaleesa. I called Jaleesa off of my phone number. It's an 858 number. It's registered to my name. It's in my name. Miss Vesey's phone number, I do not call at all. And when I was coming out here, I seen Miss Vesey in the back. Miss Vesey can attest to you. I haven't called her or I haven't called her. I know the contact.
And now the judge has a very specific problem to solve. Johnson says he's calling another girlfriend, while the prosecution says the number belongs to the protected victim. Notice what the judge does next. Instead of immediately deciding who's telling the truth, the court starts testing the explanation itself. If these two women know each other, why would they supposedly share the same number?
So I know I ain't supposed to have no contact with Mrs. Vesey at all. So I call my other girlfriend, which is Jaleesa. And once you hear the phone, once you get the phone records, the 100 and whatever times, I'm not too for sure how many times I called her, but once you get the phone records and you hear the phone records, you'll clearly hear that it's not Mrs. Vesey, it's Miss Jaleesa that I am talking to on the phone. Now, if you can hear the records as well, you hear me on that phone call, those same phone calls, telling Jaleesa that I cannot have no contact with Mrs. Vesey And for her, I can't have no third party contact as well with Mrs. VC. So once y'all able to get the contact or the phone records or whatever to my attorney in this court, y'all can listen to them and make the determination. But I don't call Mrs. VC, and Mrs. VC is in the.
All right, well, let me ask you this then, since you decided to volunteer this, as between your two girlfriends, would there be any reason they would share a number?
No, there's no reason that they would share. No.
So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same?
Here's where the defense raises an important point. A phone number alone doesn't necessarily tell the whole story about what happened during a call. The substance of those conversations could matter, but the judge doesn't have that evidence in front of him yet, and that's why this becomes a temporary courtroom decision rather than a final determination of whether Johnson actually made prohibited contact.
Number that you're calling from the jail.
Now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. VC, but Mrs. VC is right there.
Okay, do these two women know each other?
Yeah, they know each other for
Oh.
sure. I mean, like I said, we was in a three-way relationship. So like they know each other for sure.
Okay.
And Mrs. VC right there, if you would like to call her up here.
No.
This is a crucial distinction. Johnson is worried that losing phone privileges could cut him off from his family, but the judge is looking at it from the perspective of an alleged bond violation. At this stage, the court doesn't have to resolve every factual dispute before taking an interim precaution. The attorney can review the calls, and the judge has already left the door open to restoring those privileges later.
She can attest it. I can't talk to her. I got both of them pregnant at the same. You know what I'm saying? So like,
To be fair to James, Your Honor, what we're not hearing is anything about the substance of those calls, whether he's talking about court or proceedings or anything directly related to Miss VC.
The same time?
yeah.
Okay, all right.
Yeah,
Checking.
yeah.
Go ahead. No, my bad.
Yeah.
I'm sorry, Mr. Bernstein. I didn't mean to interrupt.
I was just saying, Judge, what we're not hearing is the substance of those calls that relate specifically to Miss VC. Anything that would indicate that it is Miss VC herself. We're talking about the number, but as far as like what's on those calls, I mean, what we're not hearing does kind of support what James is saying, that he wasn't calling Miss VC, Your Honor.
Okay, I don't. So there's no way without me seeing. I mean, you haven't seen them, Mr. Bernstein, that we're going to know. But my posture on those cases is that if the people are representing to me that the number is the same.
This is a crucial distinction. Johnson is worried that losing phone privileges could cut him off from his family, but the judge is looking at it from the perspective of an alleged bond violation. At this stage, the court doesn't have to resolve every factual dispute before taking an interim precaution. The attorney can review the calls, and the judge has already left the door open to restoring those privileges later.
Same. I don't know what's going on. Doesn't matter to me. All I know is that the number is the same. I'm not sure what those conversations are. Mr. Bernstein will listen to it, but this time I'm going to revoke your phone privileges. And certainly, Mr. Bernstein, after you hear the calls, if the court needs to reconsider that, I will entertain that and potentially restore his phone privileges. Okay.
So that means is when you revoke my phone privilege, is it to that number or is it to all my family?
I'm sorry.
Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number?
I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you. They can get to me. I'm not saying I might not restore them, but at this point, this is what I'm going to do.
Okay.
Okay?
All right.
I'll get on it fast.
Yeah, because I need to talk.
So his phone privileges at this time are revoked. With reference to the bond amount, when is the other hearing on?
It shouldn't.
So, and that's the case that bond's been denied.
Yes.
So, okay,
He's not going anywhere anyway.
Well,
So
I know. I get that. That was going to be my point. I just wanted to check the dates. And so I'm just going to continue his bond as it's currently sat. until we can get to the bottom of it, because he's going to have a preliminary examination before that other case comes out. I'll set preliminary examination in person, July 30th, 2024, 9 a.m. That's before me. Thank you.
Thank you, Your Honor.
Same time.
What we just witnessed was a tense bond hearing centered on alleged violations of a court-ordered no-contact condition. Prosecutors told the court that James Johnson had made 105 calls to the victim's personal number and another 110 calls to a family line where the victim could answer. Johnson strongly denied contacting the victim, explaining that he was calling another girlfriend and insisting that the actual phone records and recordings would prove his side of the story. But the judge faced an immediate problem. The prosecution identified the number as belonging to the victim, while the defense had not yet reviewed the recordings or confirmed who was actually speaking. Rather than treating the disputed allegation as conclusively proven, the judge took an interim position and revoked Johnson's phone privileges, while leaving open the possibility of restoring them after his attorney reviews the calls. The court also continued the existing bond arrangement and set a preliminary examination for July 30th, 2024. The bigger takeaway is that bond conditions are not something a defendant can simply ignore, especially when a no-contact order is involved. At the same time, this hearing shows why evidence and verification matter before disputed allegations can be fully resolved. What do you think? Was the judge right to temporarily revoke the phone privileges until the recordings could be reviewed? Drop your opinion in the comments, hit like if you want more real courtroom breakdowns, share this case with someone who follows legal drama, and subscribe for more courtroom moments and case analysis.